And with that, Representative Mueller, we also have your bill, House File 418. And I think I'm going to get this correct here, that your motion is that this bill be referred to the Ways and Means Committee with a recommendation that it be referred to the Committee on Government Operations. Did I get that right?
Yes, I think
Wonderful.
that sounds correct.
So Representative Mueller so moves. Representative Mueller, Bill House File 418 is before us.
All right, thank you.
Representative Mueller, you have a delete all amendment, the DE2 amendment. Is it your intent to move that amendment at this time?
It is not, Mr. Chair. At this point, we will not be moving the delete all amendment, so we'll just be working off the original House File 418.
Very well. Then House File 14 is before us as introduced. Representative Mueller.
Thank you so much, Mr. Chair, members. And this really is just, these things that we're talking about really are just the beginning of the conversation here. And one of the things that I think is really important as we're moving forward in how we can best address sexual assault issues in the state is to look at our criminal sexual conduct statutes. The purpose of this bill is to create a working group to really examine how our criminal sexual conduct statutes are working or not working and look at rewriting all of those statutes. And to talk a little bit about why this is necessary, over the years, the statute has been amended time and time again. Even the last couple of hearings, we've heard about some of the situations that aren't covered by statute, which we think should be covered, or the exclusions like marital rape, touching a clothed buttocks, teachers having sex with 18-year-old students. Representative Miller, you made a point at the hearing the other day about you hated the loopholes in these cases. And it seems like we're just constantly fixing these loopholes. And what happens is, as a result, these statutes have become very unwieldy. With sexual contact, there are 3 separate definitions of sexual contact depending on what kind of charging provision you're using. It's gotten very complicated. And when we're just coming back and trying to close these loopholes, it seems that we are denying victims justice and we're not holding offenders accountable. And here's another loophole I wanted to explain to you. So the Minnesota Supreme Court in December of 2018 issued a decision in the Ortega-Rodriguez case. And in that case, they reversed a first-degree criminal sexual conduct conviction involving the abuse of a 10-year-old over the course of several months. And the court held that the statute required that penetration occur and that the genital contact to genital contact was not enough, that there actually had to be penetration. And so that highlights yet another loophole in our law. I'm working on legislation to address that issue. But it also shows the broader concern of cases that I've seen as a prosecutor, especially in child sexual abuse cases, where we're asking children to describe if there's contact or penetration. And for children to be able to know that that happened or articulate that is extremely difficult. And a lot of our laws make us ask children these kinds of detailed questions. So that's just one example of an area that I think really needs to be looked at. And I have several testifiers here that are going to talk about some of the changes. Cheri Townsend, if you want to come up, is a prosecutor. I've worked with her for a number of years, and she's got a lot of knowledge on this issue.
Very well. Representative Mueller, we may want to ask, why don't we ask the others to come up and be at least nearby, because we're going to be a little bit pressed for time. I want to make sure we maximize.
That would be great. The other testifiers are Lindsay Brice from Mincasa. We've got Asma Mohammed from Reviving Sisterhood and Megan Arriola, who is a survivor. And I just wanted to make a note about survivors. I did let some organizations know that our committee is always wanting to hear from victim and survivors. And so the mic is always open to hear about these cases. We really appreciate Ms. Granda coming and talking to us today. We want to hear your voices. And so any of these bills that we're discussing, and I think I speak on behalf of my other committee members as well, please always feel free to share those concerns with us. And thank you for coming, Ms. Granda.
Thank you, Representative Mueller. Again, consistent with the community-centered approach to public safety. Ms. Townsend, welcome to the committee.
Thank you very much, Mr. Chair and members of the committee. I'm very pleased to be here. My name is Cheri Townsend, as Representative Mueller indicated, and I'm a prosecutor with the Hennepin County Attorney's Office. I'm currently a senior assistant Hennepin County attorney, and I supervise child abuse prosecutions in addition to vulnerable adult prosecutions, and have a trial team as well. It has been my privilege over the years working in Hennepin County to be able to work with any number of survivors of sexual assault, be it both adult and child survivors. I have worked at the Hennepin County Attorney's Office as a prosecutor for 7 years. I've been working as a prosecutor for 20 years total, including working at the Minnesota Attorney General's Office and the Dakota County Attorney's Office. So all told, in my years of experience, I've had so many opportunities and privileges to work with numerous victims of sexual assault and to navigate some of the statutory issues that we have with sexual assault cases. I would note that Representative Mueller asked that I be here today to talk a little bit about just a couple of experiences that I've had as a prosecutor dealing with some of the legislative challenges that there are in relation to the bill that she has proposed to do a full review of those. And I have two circumstances that I'd like to just speak with the committee about today in general. First of all, I'd like to just speak about the issue that Representative Mueller just talked about with the Ortega-Rodriguez case that was just recently decided by the Minnesota Supreme Court. As this committee may be aware, the definition in cases involving criminal sexual conduct in the first degree, conduct that involves sexual penetration, is penalized in addition to conduct involving children under the age of 13 when it is bare genital to genital contact. And my understanding of that legislation, that the addition of the bare genital to genital contact, was that many years ago that legislation went through because of the experiences that children have, certainly children under the age of 13, in describing penetration. As Representative Mueller indicated, as prosecutors, we are often in the position of having to talk with the most vulnerable of survivors about the most difficult and challenging of experiences that they have. Particularly with children, it presents a challenge because children are placed in a position to describe acts that they should never have to know about in the first place. And certainly the issue of sexual penetration is an extremely difficult circumstance for a child of any age to describe, but certainly as the legislation reflects the age of 13 or under the age of 13, to describe what that means, certain body parts and how those body parts were involved in what happened to them is very difficult. So that legislation where it describes first-degree criminal sexual conduct can involve not only penetration, but bare genital to genital contact is extraordinarily helpful for prosecuting cases involving children under the age of 13. The issue that presented itself, and certainly I think in the Ortega-Rodriguez decision, was that portions of that statute, criminal sexual conduct in the first degree, only reference sexual penetration and do not specifically indicate that included in that would be the bare-to-bare genital contact if the victim is under 13. So it is my belief, and I believe Representative Mueller's bill, to make sure that there is a review of the statutes to fix any of those issues as it relates to whether the definition or the conduct that is penalized specifically permits, and as I say in the CSC1 statute, both sexual penetration or bare-to-bare genital contact is also covered. And so that is a circumstance where I know that was a prosecution, I believe in Ramsey County, where that happened, but where the statute, because it only said sexual penetration for that portion that the case was prosecuted under, and the conduct was bare genital to genital contact, a fix of that legislation would be extraordinarily helpful for us to avoid any future circumstances such as that. As I've indicated, I've had the privilege to speak with numerous children who have alleged and who have been victimized of sexual assault, and the language in the statute that prohibits and makes that criminal sexual conduct in the first degree is is something that the genital-to-genital contact is something that we deal with on a fairly regular basis in our child abuse cases in Hennepin County, and I know counties throughout the state of Minnesota, or many of whom I get to work with in our capacities as child abuse prosecutors and sexual assault prosecutors. As it relates to another example of a case where a review of the legislation and to take maybe amendments that were put in and not necessarily contemplated and working together is the sexual contact statutes, specifically sexual contact in the second degree, criminal sexual conduct in the second degree and in the fourth degree, where the prohibition is against sexual contact. A case example that Representative Moeller and I spoke about that I've experienced was a circumstance where we were prosecuting an individual who sexually assaulted a woman who was not conscious at the time. And the allegation of the sexual assault involved his genitalia to her mouth area, and she was not conscious for the sexual assault. She did not know that it was actually happening at the time it was happening. Because the case was, at least initially, largely circumstantial, we did charge a criminal sexual contact in the fourth degree, believing that because she was physically helpless, the definition of sexual contact contemplated the perpetrator's intimate parts against the complainant's non-intimate parts. But what we found is that the definition of sexual contact at subdivision 11 of 609341, it has two separate definitions of sexual contact, and one of the definitions applies to certain provisions of the statute, and the definition that dealt with our particular conduct did not apply to the physically helpless provision. It only applied to certain subdivisions not included in the set of facts that we had. So that was an example that immediately leapt to mind as Representative Moeller was talking about the possible review of sexual assault statutes and trying to see what, if any, reconciliation of any amendments or changes that had happened over the years, how that could impact or how that could be effective. This is my closest example of a circumstance where the statute did not permit us to prosecute the individual for sexual contact because the definition of sexual contact was not applicable to his conduct if the victim was physically helpless at the time. We certainly were able to prosecute the individual for criminal sexual conduct in the third degree and attempted criminal sexual conduct in the third degree. So we were successful in our prosecution, but that certainly was an issue that presented itself for charges that we believed would be applicable to that particular case. So I appreciate very much the opportunity to come and just highlight a couple of examples of circumstances that, as a prosecutor who's been doing these cases for several years, I welcome a review of the sexual assault statutes and reconciling any issues or differences in definitions that may or may not impact future prosecutions. Thank you, Mr. Chair.
Attorney Townsend, for helping to highlight some examples of why the importance of reviewing our state sexual assault laws as they apply to the ability of our prosecutors to pursue justice equitably, fairly for victims. We have Representative Moeller about 5 minutes, so but let's get in as much testimony as we can, and then we'll proceed forward.
Sure. I'm going to turn it over to Lindsay Brice right now from INCASA. If you could just quickly kind of summarize this, that'd be great.
Mr. Chair, members, thank you for inviting me here again today. I've been in front of you. This is the second time this week. I was actually supposed to be here yesterday as well. My name is Lindsay. Pardon?
I'm sorry. Go ahead.
My name is Lindsay Brice. I'm the Law and Policy Director at the Minnesota Coalition Against Sexual Assault. And I'm going to skip what, I think everybody here knows what MNCASA is, so I'm going to skip through that. But I'm here to speak in support of this bill and to thank Representative Mueller, co-authors, and yourself, Mr. Chair, for advancing this conversation. Just briefly, MNCASA does fairly substantial policy work. And we have a policy committee that consists of representatives from member programs, allies, criminal justice system professionals, victim survivors, and others. We break that committee down into multiple subcommittees. And our Access to Justice subcommittee has historically had substantial prosecution input and involvement. And we have spent, both that committee and our Victim Services Subcommittee has spent substantial time over the last years working on exactly this issue. What different segments of this statute are problematic and need to be fixed? You've heard, just this week, you've heard 2 different bills that came out of that work. You've heard about voluntary relationships and how problematic that statute is. And you've heard about the problems within the buttocks bill. And you discussed a bill that would amend that statute to define the intentional touching of clothed buttocks as criminal. That some of where that came from is out of MNCOS's policy work. So we've been receiving a strong message from advocacy programs, specifically in victims and survivors, that there are a number of problems within these statutes. Most recently, we've been having a number of conversations around the prosecution or lack thereof of alcohol and other substance-related incidents, so in sexual assault cases. So we started running through our usual process and working within our policy committees and subcommittees on that language, the physically helpless and mental incapacitation language. In fact, if you've seen our agenda, you'll see some specific mental incapacitation language suggested in there. However, we've come to the conclusion that a comprehensive approach of this entire statute is really the way to go because there are so many different problems. Now, I say that, however, I still want you to support the other 2 bills that you heard this week because we've had a comprehensive, that has been through substantial vetting already. So we're further along in that process. But instead of continuing to do this piecemeal, we're asking you to pass the pieces that we've already done, and then pass a bill that allows us to really comprehensively do some multidisciplinary work with an intentional focus on meaningful input from victims and survivors and marginalized communities and some of the folks that are most impacted. And this is a priority for us. Thank you.
Thank you, Ms. Brice.
Yeah, go ahead.
Thank you, Chairman and committee members. My name is Asma Mohammed, and I am the Advocacy Director at Reviving the Islamic Sisterhood for Empowerment. Thank you, Representative Mueller, for inviting me. So at Reviving Sisterhood, we convene healing circles for survivors of sexual violence. It's just one of the many things we do. But in that, we have learned a lot, and part of those learnings have been that survivors need to lead the way. So in that, I am a survivor myself, and just this past December, I shared that I was assaulted when I was 12. So that was just over a month ago. And afterwards, 5 women from the Muslim community, all women of color, reached out to me and said that the same man had assaulted them. It's been 15 years, and I've just become comfortable enough to talk about this. And now the statute of limitations does not protect me. I have no way to report this. None of those women can report this. So that man thrived off of our silence and knowing that most children don't talk in the very beginning, right? So in talking about this statute and convening like a survivor-led approach, and by prosecutors who've dealt with survivors, I think is super important because we are reminding everyone that survivors have the trauma that they've experienced is the center of all of this. That is where the legislation should come from. So, of course, I also support many of the bills that have been coming through this committee over the past few days and then some that'll come next week. But if we hold some kind of convening, if we have this working group, we're going to allow for some of that to happen, I think, in a way that is hearing survivors' voices. That's all. Thank you.
Thank you, Ms. Mohammed. Thank you for coming forward and for asserting your dignity publicly.
Thank you.
Welcome.
Mr. Chair, my name is Megan Arriola. I'm 25 years old, a lawyer, a House of Representatives employee, so you'll see me around. I'm also a survivor of rape and domestic violence. As a result of this, I struggle every single day with the after effects of PTSD, depression, and anxiety. I am proudly open about my decision to manage these illnesses with medication, with antidepressants and through the medical marijuana program that the state recently enacted PTSD as a pre-existing condition, and I am so grateful every single day for that. I spend more than 50 hours a week on top of my full-time job running an online support group for rape and sexual violence survivors. We currently have approximately 1,500 members from across the United States and a few international members as well. I speak to high school students at private Catholic high schools about the importance of consent, healthy relationships, and healthy sexuality. I do all of this unpaid in addition to my full-time job because I feel the need to provide the services and information that was lacking when I was grappling with the after effects of my rape. I was assaulted when I was 17 by a boyfriend. When I got to law school, it broke my heart to learn when I studied criminal law that my rape would not have been prosecutable. Even though I was 17 when it happened and the statute of limitations on my crime only expired in December of 2018, I knew that reporting would be fruitless because our current laws and our current societal attitudes toward survivors would not let me receive systemic justice. I've received justice in other ways by speaking out, by telling my story, and by providing support to other survivors. But for many survivors, that's not enough. They need justice in the system. If I had reported when I was 17 and when this first happened, I learned quickly in law school from my professors, my classmates, and through statutes and previous decisions what I would have faced when I had reported. Questions about why I didn't scream, why I didn't tell someone sooner, why I continued to date him after he raped me. I had consented to vaginal sex immediately before he sodomized me, and that would have been viewed as consent to all sexual activity under current interpretations of the meaning of consent. Statements like, how could you have known you didn't want it? How could he have known you didn't want it? You were already naked. What did you think would have happened? These types of victim-blaming questions are still being asked of survivors to this day when they find the courage to report. When I say I hear from survivors every single day, I mean it. I hear from hundreds of survivors in our group. Every time I think I've heard it all, some new way that a person has been sexually violated comes across my screen. So many of these traumas cannot be prosecuted for a number of reasons. Police departments across the country and across the globe are simply lacking the violence about how trauma affects people, who can commit sexual violence, and who can be a victim of sexual violence. What a victim survivor will need from their reporting officer in order for their story to be told is crucial. I don't blame individual police officers. I don't blame individual judges or individual lawyers. They hurt to hear every single time these questions are asked, but they reflect a societal misconception about sexual violence and trauma that is pervasive in our system. I'm not so blinded by my passion for this subject that I don't recognize that all crimes are not prosecutable. No matter the type of crime, sometimes the investigation just does not provide enough to support a criminal charge. But what law enforcement agencies can do is to strive to not re-traumatize the victims when they report. Just because a case does not move forward in the courts doesn't mean that a victim survivor was lying, and that should be treated as such. It costs exactly $0 to treat a trauma survivor with respect, so I hope that's reflected in the fiscal note for this bill. That was a joke. As you heard from the experts on this subject, statistics and what we need from survivors don't lie. There's a fundamental misunderstanding about sexual violence in our country's criminal justice system. I believe that under the dutiful advisement of groups like MnCASA, RISE, and the Minnesota Coalition for Battered Women, this working group can do some concrete good. Putting together in one place representatives of all the types of groups where a victim survivor may seek help will be a meeting of the minds unlike any that Minnesota has seen for this subject. This exchange of information, expertise, and stories of impact like mine is a valuable currency that cannot be undervalued. Working groups like this one will put Minnesota on the forefront of a national call for reform around sexual violence laws. We can lead the way to be an example of respect, belief, and equal justice under the law for others. I'm not an expert in this field. I'm not a certified professional, a stakeholder, or an elected official. I'm just a survivor speaking out of love for the survivors I support every single day. And I ask you to consider the good that this working group will do for Minnesota survivors today and in the future. Thank you, Mr. Chair.
Thank you, Ms. Arriola. Thank you for asserting your power and your dignity here today.
Thank you.
Members, we are past our time of adjournment. My understanding is there is no committee here. We have floor session in about, 20, 25 minutes. The chair is certainly willing to entertain a few more minutes if you have questions or comments that you wish to offer at this time. for Representative Moeller, and then we'll move forward. Yes, please, Representative O'Neill.
Thank you. Just a really quick comment, because somebody talked about statute of limitations. And as we had talked, I think offline sometime this week, it was a really full week, so I don't remember which day. But I'm very excited that when I do bring my bill back, it has a component of eliminating the statute of limitations. And so, and maybe they still can't go to court because you still need to prove it in a court of law beyond a reasonable doubt. But I think it gives some dignity back to those that were victimized and realize that those cases do matter, your trauma does matter. And I think, when you talk about what you just said of there's 5 victims that you know of, you can put those together and actually come up with a case now. And so I'm really excited to bring that forward whenever we bring that back up, Mr. Chair, with the Hannah bill. And so I just get excited when they say things like that. I'm like, I have a bill for that. So thank you, Mr. Chair.
Senator O'Neill, I look forward to the hearing on Hannah's bill. Other members? Anyone else that wishes to comment on the bill? Then Representative Mueller, you get the last word here.
All right, well, I don't have anything more to say than what these, all the testifiers had to say, and I just want to thank them again for coming, for having the courage to not only have your voice be heard, but to help so many other people along the way. We really appreciate it, and we hope to see you again a lot throughout this process. So thank you.
Thank you, Representative Mueller. I do believe this is what community-centered public safety is all about. So with that, Representative Mueller renews her motion that House File 418, I want to make sure I get this right, House File 418 be referred to the Committee on Ways and Means with a recommendation that it be re-referred to the Committee on Government Operations. All in favor of that motion, please say aye. Aye. Opposed, same sign. Motion prevails. Thank you, Representative Mueller, and I look forward to seeing this bill as it journeys its way back to our division.